So the first thing we want to talk about is what's IEEPA, right? What's the background and the legal authority? Now, you know already that this is the International Emergency Economic Powers Act, 50 USC 1701-121708, and it grants the President of the United States broad authority to regulate economic transactions following the declaration of a national emergency. Now, there always needs to be a national emergency. Debatable whether that was won last year, but the president certainly saw it that way. So he invoked IEEPA to impose sweeping tariffs on most U.S. trading partners, arguing national emergencies related to fentanyl trafficking and unfair trade practices. And on February 20th, the Supreme Court ruled in 6-3 that IEEPA does not authorize the president to impose tariffs, and that's invalidating $133 billion in collected duties, and that includes yours as well, probably. Otherwise, you wouldn't be in this webinar, right? So this is a ruling that creates the basis for the duty refund that we are talking about. It's the largest customs refund opportunity in U.S. history. So a few numbers: 133 billion US dollars estimated duties collected under IEEPA tariffs in 2025. 53 million import entries affected across 300,000 and more importers. It was a 6-3 Supreme Court majority ruling. It is now clear IEEPA does not authorize tariffs. It's done for sanctions, it's done for a lot of things, but it's not for tariffs. And the big date, of course, was the 20th of February 2026, the date of the Supreme Court ruling. The refund clock starts now. This is all important because when your IEEPA import and your payment of duty dates back a long time, that can affect the way you'll have to deal with it. So we're not going to go through all of that happened, but what you need to understand is that the IEEPA tariffs, they fall into several buckets, okay? So it is not only the reciprocal tariffs, so you will remember that this was the Liberation Day on the 2nd of April 2025, where the president stood in front of the White House with this board, which had all the tariff lines on it, which imposed tariffs of 39% for Switzerland, 20% for the European Union, 15% for Liechtenstein, and even, what was it, 10% on Christmas Islands for the penguins, right? So this is that one, the Liberation Day. And it had a 10% tariff baseline on virtually all US trading partners, so that's the starting point. And then other countries received, as I said, higher country-specific rates. And then we had Chapter 99 specific headings for this. So in this case, we remember 99030133 very well, because this is the one that started the IEEPA heading. So what would that mean? Well, it would mean you would declare the customs entry under your normal MFN or normal trade relations tariff. And then below that, you would record the 99 tariff, right? The Chapter 99 tariff, and you would have 19030133, and then you would have 25%, 39%, 50%, whatever it was. And if there was no country mentioned in that chart, then we would have our baseline 10%. So Colombia, for example, was not mentioned, so they would always be hit with the 10%. So that was country specific, based on unfair trade practices and more imports than export trade imbalances. Okay, so that was mainly on the 2nd of April. Before that, the president already hit Mexico and Canada, so the U.S. closest trading partners, with various tariffs related to drugs and also immigration. So fentanyl tariffs, they were known, and that was 25%. Then it changed back to some other percentage rates. Canada and Mexico were hit first. There's something on energy as well, but China was always in the mix as well. First starting with fentanyl tariffs on 10%, then more, and it went to ridiculous amounts, over 100% over the course of the year, and then dropped down again. Everything to do with drug trafficking, and officially the authority for that was the IEEPA. So we're talking about the fentanyl tariffs of Mexico, China, and Canada. We're talking about the reciprocal tariffs, the country-specific tariffs. And then throughout the year, these were amended and changed. We had subsequent executive orders that escalated rates, especially with China. We had very high levels with China. Canada rates increased. And then towards the latter end of the year, we also had an expansion of specific sanctions for specific reasons. No, not sanctions, duties. tariffs for specific reasons. So reasons such as electoral interference or buying Russian oil. Were all reasons to impose additional tariffs on countries such as Brazil or India or Russia, etc. They were all based on IEEPA. So all of these tariffs were IEEPA tariffs with slightly different focuses, and they're all subject to the same Supreme Court ruling. And IEEPA also eliminated the de minimis exemption, Section 321, for goods from China, subject to low-value shipments of duty. This also was covered by the Supreme Court ruling. However, that still stands. While the IEEPA tariffs in general are gone, the de minimis elimination remains. So what was ruled on the 20th of February 2026? So as I've already explained, there was a vote of 6-3 of Supreme Court justices, and it stated in a nutshell that the IEEPA regulation does not authorize the president to impose tariffs. The core ruling was that the International Emergency Economic Powers Act does not grant the president the authority to impose tariffs as a form of economic sanction. The court consolidated two cases challenging the fentanyl tariffs and the reciprocal tariffs and found that tariff imposition requires specific congressional authorization, which IEEPA does not provide. The Supreme Court clarified that the U.S. Court of International Trade has exclusive jurisdiction over cases involving tariffs and trade matters. This means that any litigation to obtain IEEPA refunds must be filed at the CIT, not the federal district courts. The CIT would be the only venue for tariff refund lawsuits. However, they don't seem to be necessary because we now have CAPE in place. What the ruling did not address, it said nothing about how or whether the government should return the collected duties, which is interesting. And it was generally thought that this process would be a mess. Okay, now there were some opinions that the refunds shouldn't be issued or should be illegal. However, in the end, CBP decided that we're going to refund all of this, and we have a mechanism called CAPE. Interestingly was the comment from the DOJ, the Department of Justice. If tariffs imposed on plaintiffs during these appeals are ultimately held unlawful, then the government will issue refunds to plaintiffs, and that is what that's what we're basing on our current action.